coercion, undue influence, fraud, misrepresentation, the after effect of that particular contract is voidable. Don't forget it. Coercion, undue influence, fraud, misrepresentation. The after effect is, it is voidable. It is only voidable. It is at the option of the parties. If you're accepting it, it becomes valid. If you're not accepting it, it's void. Very important. And the last one, that's mistake. If the mistake is with regard to the fact, or mistake as with regard to law, or only one person is under having an impression of mistake, then you can say that it's not voidable itself, it is valid. But if both the parties, then if there's a mutual mistake, then you can say that the after effect of that particular contract or that particular agreement, that is void. So only with respect to mistake, it is void. That mistake should be mutual mistake. Then only the after effect of that particular agreement is void. And with respect to coercion or undue influence or fraud or misrepresentation, the after effect of that particular contract is only voidable. Very important. Now, as we have discussed, the consent is said to be free when it is not caused by coercion. What is coercion? As per the English law, instead of coercion, the word used is duress. Duress means actual violence. Duress, actually the definition is, it is an unlawful or illegitimate form of pressure or intimidation used so as to induce the other person to enter into a contract. That is duress. In Indian law, we could say that there's coercion. So duress is unlawful or illegitimate form of pressure or intimidation. Why such intimidation pressure is used? For inducing the other person to enter into a contract. So duress is only with respect to the parties to the contract. They can only cause out violence or threatening or pressure or intimidation. But what is coercion? In Indian law, what is coercion? Coercion is committing or threatening to commit any act that is forbidden by Indian Penal Code, or unlawful detaining or threatening to detain any property. And what is the main intention of all these acts? Inducing the other person to enter into contract. So in the case of coercion, it need not be the parties to the contract. Even a third party can coerce you for entering into a contract. If even a stranger can coerce or actually threaten you. For what? Inducing the other person for entering into contract. This is coercion. That is simple example. For example, Girish. I am kidnapping Girish. Okay. And I am conveyed to another place. Why? What for? For entering into a contract. For getting the property of Girish. So that is committing an act that is forbidden by Indian Penal Code. So kidnapping is an offense. Okay. And threatening to commit any act that is forbidden by law. Suppose I'm pointing a gun and asking Girish to sign an agreement. It's coercion. So that is coercion. Either you are committing or threatening to commit any act that is forbidden by law. Or you are unlawfully detaining any property. One agent, he is detaining the books of account so as to enter the principal to enter into a contract. That's intention. Or threatening to detain any property. There was an important case law with respect to coercion, that is Renkanayakamba versus Alvar Shetty. In that case, a widow was coerced to adopt a son Otherwise, the corpse of her husband will not be removed or taken. So she was forced to adopt the son. Otherwise, the dead body of her husband will not be taken. That is a disrespect to a cause, and that's a disrespect to the corpse, and of course that is an offense, and it's punishable under section 297 of IPC. So disrespect to corpse. So what is the after effect of this coercion? You can either accept it or you can deny. You're accepting, it becomes valid, it's not void. So the effect is voidable. So that is coercion. So I think it's clear. Coercion means committing or threatening to commit any act that is forbidden by Indian Penal Code, or unlawfully you're detaining the property or threatening to detain the property. And what for? What's the intention behind all this threatening or committing all these acts? Inducing the person to enter into contract, and the ultimate effect of that particular contract or it's voidable. The next is undue influence. What is this undue influence? With respect to the two parties, one should be in a dominant position so as to dominate the will of the other. As a result of that dominant position, the person who is having that dominant position is obtaining an unfair advantage over it. So there should be a real or apparent authority. That is, what is the sort of relationship? A teacher and student, who is having the dominant position, teacher. A doctor and patient, advocate, client, spiritual advisor, disciples. These are some of the examples of this relationship. You can say that the relationship should be, it's a fiduciary relationship. Relationship arising out of trust and confidence. So, in the case of teacher, student, or doctor, patient, advocate, client, or spiritual advisor and the disciples, one is in a dominant position, other is subservient. As a result of that dominant position, that dominant person is obtaining an unfair advantage. That relationship is out of trust and confidence. Or there are some instances where a person is mentally incapacitated, maybe temporarily or permanently, maybe due to illness, maybe due to illiteracy, maybe due to age, or maybe due to some mental or physical disorder or distress. So there too, one person is in a dominant position. So one of the best case law was Alcard versus Skinner, where a mother superior has taken or grabbed the entire property of a sister. But what is the after effect? The ultimate effect of that undue influence is, of course, it is voidable. You can just, in the case of an undue influence, you can file a case to set aside this particular contract. In Alcard versus Skinner, later on a case was filed because the entire property was actually taken by mother superior, because there is an undue influence between them. As a result of that fiduciary relationship, the entire property was given. But later on, they filed a case for getting back the property, but there was an actually unreasonable delay. After many years, they have just claimed for that. And because of that delay, that particular suit was dismissed. So you can set aside that contract, but still that should be done within a reasonable period of time. So that is undue influence. So one should be in a dominant position. And as a result of the dominant position, they have taken the unfair advantage. There should be a real and apparent authority, and there should be a fiduciary relationship. Or in some instance, if a person is mentally incapacitated, maybe because of some illness or age, or some mental or physical disorder, that circumstance to this particular sort of undue influence may arise. So in these cases, as we all know, it's voidable. You can even set aside this, but that should be done within a reasonable period of time. Another is a fraudulent transaction. If I'm concealing a fact and I'm selling anything, for example, I'm just selling my horse to Girish. The thing is, that particular horse is unsound. In spite of repeated inquiry by Girish, I have not just spoken a single word with regard to this unsoundness of mind, unsoundness of this particular course. That's a fraudulent transaction because I've concealed the fact. Even if it is for, that is, injurious reliance. You could say that in case of fraudulent transaction, it's injurious reliance. But still, what is after effect of this fraud too? It's also voidable. Another is misrepresentation. Always, we could say that it's very difficult to distinguish between this fraudulent transaction and misrepresentation. One of the best important cases with respect to this misrepresentation is Derry versus Peak. In that, a company has issued a prospectus, very clearly stated that they can run their particular company using steam or electrical devices, electrical engine. Earlier, they have used animal power. Now they can use this electrical power or steam power. Actually, when they want to use this with the steam or electrical power, what they have to do is they have to get the consent of the Board of Trade. This company thought that it was just a formality. When they can approach this Board of Trade and just a formality, they will just accept it and they'll give assent or sanction to it. But what happened is, when they approached the Board of Trade, they have not given sanction. But while just viewing this prospectus, many shareholders came. So first it was said that it was a fraudulent act. But later on we could say that it is not fraud. There is no concealment of the fact. They thought that it was just a formality. While approaching the Board of Trade, they will get the sanction. But unfortunately, the sanction was not given by them. So that was only an innocent representation. They didn't have any intention to cheat. They didn't have any fraudulent intention or fraudulent mind. It was only an innocent representation. That is only a misrepresentation. And the after effect, as we all know, it is voidable. And the last, with respect to this particular free consent, is mistake. I told you, when it is a mistake of law or mistake of fact, or even if only one person is having a mistaken belief, the ultimate effect is valid. You cannot say it is voidable itself. It is valid. But if it is a mutual mistake, that is, I am offering a horse to Girish. Girish have accepted it. But whenever we are just entering the contract, at that particular moment, that horse was not, actually, it was not living. It was dead. It has expired. But I was not aware that that horse is no more. Horse is dead. But without knowing that, I have just entered into a contract. I have offered and Girish have accepted. So both of them have mistakenly entered into an agreement. So if it is a mutual mistake, then you can say that the after effect of that particular agreement is void. So this is with respect to the free consent, that is over. So coercion, anti-influence, fraud, misrepresentation is voidable. If it is a mutual mistake, only you could say that it is void. So is there any doubt? You can discuss.